Hi, my name is Jamahl Kersey. I'm a criminal defense and immigration attorney at Kersey Law, and this is a quick video informing you on what goes on at arraignment, the first hearing in a criminal case. The first hearing in a criminal case is called the arraignment. The primary purpose of an arraignment is to give the defendant, the person accused of a crime, written notice of the charges and for the defendant to enter a plea. Arraignments are usually held within 48 hours of a person's arrest if they're in jail. Now remember, that's excluding weekends and holidays. If they've been bailed out or were issued only a citation, then the arraignment typically happens either weeks or even months later. There's usually a lot going on at the arraignment calendar. There's a lot of nervous energy, lawyers hustling and bustling around, and in-custody defendants being shuffled around the tank where they're being held. So prior to appearing in court, your lawyer, whether they're a public defender or private counsel, will review with you a document called a complaint. The complaint has your name and date of birth on it. It lists the charges, the prosecutor's filing against you, and as for each charge, it'll also list the exposure or the amount of time that one can receive for being convicted under that code section. Your attorney will also go over your constitutional rights with you. They are the following. 1, you have the right to remain silent. 2, you have the right to a public trial by jury. 3, you have the right to confront and cross-examine all witnesses against you. And 4, you have a right to present evidence on your behalf. Now, after you've gone over this and other information with your attorney, eventually the judge will take the bench. The bailiff will call each case one by one, and your attorney will answer up on your behalf, making his or her appearance. The attorney will generally enter a not guilty plea at arraignment. It's a very rare situation that a guilty plea would be entered at arraignment, if nothing else for the very reason that none of the discovery, that is the police reports, photographs, videos, witness statements, and etc., will have yet been produced. And so it's the government that has the burden of proving that you're guilty. It is not your burden to prove that you're innocent. And so therefore, prior to admitting guilt, you'll want to review the evidence against you and have an opportunity to discuss defense strategies with your lawyer. After the plea is entered, the judge will address bail. Now, with respect to bail, the judge is primarily concerned with 1, whether the accused is a flight risk. In other words, are they going to show up to court when ordered to do so? And 2, whether the person is a danger to the community. That is there a risk that the person will be on the streets and harm the public if he gets out? So the judge will ask the prosecutor if they wish to be heard on bail, and at that time the prosecutor may state a brief overview of the facts of your case. They'll mention any relevant prior criminal history or any prior failures to appear. And the more serious the charges against you, the higher the bail amount will be. Your defense attorney then has an opportunity to respond. Now, generally, your attorney will mention your family ties in the area, how long you've been there, your school and employment history, your lack of criminal record or serious criminal record, and basically any good things they can say to convince the judge that you'll appear in court and that you're not a danger to the community, thereby supporting a pitch for lower bail. After the bail is set, the judge will set future court dates. In a misdemeanor case, a pretrial readiness conference will be set. In a felony case, a pretrial readiness conference and a preliminary hearing will be set. The readiness conference is when the prosecutor and the defense attorney have an opportunity to discuss the case and determine whether whether a deal can be reached. Now, if more time is needed for investigation or research, or if the case should be set for trial. The preliminary hearing, which is scheduled in felony cases, is basically a probable cause hearing. The reading of the future court dates is usually the last item that's addressed on the record. Your attorney will then thank the judge, excusing him or herself from the courtroom, and actually you'll be in front of the judge for about a couple minutes at most. It's the wait time between when you're scheduled to appear and when your case actually gets called that takes the most time, which can be up to over an hour. So that's what happens at arraignment. I hope this video has been informative. Stay tuned for more videos walking you through the criminal case process. Thanks so much for watching. Till next time.